The pillows are fluff thanks to Miss Emily. The couch is wide enough, join the family. It's all love while we laugh at first criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Oh, oh, please, my body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh please, the puppies need me. Oh please, my body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.
Hello, 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 Sofa Squad. How is everybody doing? What are y'all up to? I hope y'all are doing well. You know the drill. Drop a number one if you can hear me. Sing it loud, sing it proud. Sing it loud. Hey, Samantha, thank you for being a member for 10 months, but you've also been a part of the Sofa Squad for years at this point. I hope you are doing well. It is very good to see you. Gossip, what's up, girl? How are you doing, Kathy? If y'all don't know, Gossip, Rumor, Innuendo, check her out. Miss Kathy, she serves that tea. It's piping hot. I hope you're doing well. Welcome, Emily. So let me start over here. Hold on one second. Pardon me. Okay. We've got Tux, we've got Emily, we've got Lauren, we've got Tori. Am I missing somebody else? We got Indy. I think that's everybody. Thank you, mods, for being here. We got Ultra. Thank y'all for being here. I hope y'all are doing well. Oh, Amy, 6 months. I appreciate you being a member as well. Thank you. So y'all, I know y'all, let me tell you what, I've been out working all day long. So first of all, thank you to everybody who's been hitting me up, email, Instagram, you name it, about Schabusiness and Daryl. Okay. Now, yes, spoiler alert, I watched a very quick glimpse of what's her name? Schabusiness. Oh, Lily, thanks for being a member for 12 months. That's awesome. Hey John, hey Debbie, hey Lost Ronan. I hope your Amazon run was good today. So hey Shayna, what's up? RJB, all these familiar faces. This is such a wonderful little and way to cap off the what do you call it? Friday. Oh, Emily, the founding sofa. Fastest 14 months of my life. I love it. That's cute. Thank you. Emily's been here since day one, y'all. She's been here, well, you know what I'm saying, like virtually, basically. I mean, the sofa, it was just a little tiny kid's chair at that point. Now it's grown to be this big old thing, right? So, but thank you everybody who has hit me up about this stuff. So I've seen a quick little thing of it. I have not watched Daryl's hearing. I have not watched his whole hearing. So I have 3 videos pulled up. We're going to watch Taylor go off first. Okay. Then John says, Schabusiness says she's about that business again. Oh, I cannot, y'all. Okay. It's so true. So we're going to watch the actual fight or attack, we should say. Then we're going to listen to the hearing. I'm curious how did the hearing go? Then we're going to watch Daryl Brooks. Now for people who do not know. Okay. Yes. In Northwest, it's right there. Oh, wait, hold on. Let me get it so I can see it. So Daryl Brooks, who's the second one we'll watch, he drove a car through the, y'all help me out here. I'm sorry, I'm mispronouncing this. Waukesha, is that correct? Parade. Okay. And I'm talking, y'all, the footage, I can't even, y'all. the footage. It's like little kids. He killed numerous people, injured tons of people. I'm talking full throttle. Just imagine a parade, okay? Absolute terror, okay? But his trial, oh, Shaylee, member for 9 months. Thank you so much. I appreciate it. Um, oh, Tori, I hope you're doing okay. I'm so sorry. Everyone send love to Tori and family and all her people and pets and everyone. She's going through it right now. Hey, Heather Feather. Um, pardon me. So his trial was insane. If you thought Lori, if you thought Sarah Boone, y'all honestly not much holds a candle to Daryl Brooks. It was crazy. Okay, so there's that. Taylor Schabusiness. She essentially killed, dismembered, ate on this her boyfriend. Her trial was just as crazy in a different way. She didn't represent herself, but I mean, it's just she did horrifying things. Zero respect for life. I mean, just it's bad. And then she attacked her lawyer in her first trial. She attacked, I think, a nurse in this one, which is why she's back. She's already sentenced, like she's never leaving, right? So she's really in prison. So now she's back because she attacked a nurse, and now she attacked her lawyer at this hearing. So I feel like Daryl Brooks's, and I haven't even looked at that one other than pulling the video up. I feel like Daryl Brooks's thing is going to be like super infuriating, like in the annoying way. Whereas hers, meaning Taylor, is like whatever. Now look at this. Now before we get started, y'all, this is kind of fancy up here with the news thing. This is like real news, okay? Wouldn't it be cool if like the talking heads on news things like literally were just like this, like literally on their sofa? Yeah, maybe present a little bit more, professional presentation, than my own here. I mean, we do need that. But if they were just like chill, you know what I'm saying? Um, oh, Rand says that her 13-year-old Chihuahua Gidget passed away. Oh my God. Oh, my heart breaks for you. I'm so sorry. There's no words. I mean, that pain, there's just no words. I'm so sorry. I hope y'all make it through as best as you can with that. Oh my God. Yeah, RGB says like during the fire. Yeah, literally. Yeah, but when they wheeled her out, Lady HVAC says she did with her previous put on her previous lawyer. They put the mask on her. Yeah, when they pulled her out with that with Silence of the Lambs looking thing, I was like, girl, no. So now let's do some very quick, some not homework. What do you call housekeeping? I always want to call it homework. Sunday night we're gonna do probably Zulema from the Lori Daybell thing, and then Monday we'll begin we're gonna be streaming. We're gonna be streaming. What do you call it? Uh, the Lori Daybell trial. My gosh, I should remember the name. I'm like, it's been a long day. Sorry. But we're gonna be streaming that starting Monday. Now, also for channel members and Patreon members, if you're not a channel member of Patreon, we're doing the Book of the Month Club or whatever we do, book club. We're doing the Turpin book, Where Was God? Y'all, if you're reading that, when I tell you traumatized, I didn't want to mention it here because when we got to this part, if you're reading it, you'll probably know what I'm talking about. I'm just going to say the girl's cat. If you know, you know. I was literally driving on the road and I was like, this is the most evil stuff I have ever heard of in my life. It's bad. I'm going to try and do a few videos to put up on that. The book's like 2 hours if you put it at 1.5 speed. It's like 2 hour long book. It's super short. But honestly, yeah, Jen says, I just finished it and I was shocked. Yeah, mouth on the ground. Today, I was like, these people were so calculated evil. I can't get you there. I can't. Yeah, Jen says, I knew the story, but it was way worse than I imagined. Same. Yeah, so Alpha, one of the kids did. Sylph, and I hope I'm saying her name right. I don't really, so it depends on what it is. I used to when I was younger read a lot of Stephen King. They're asking if I read horror books, but I haven't recently. But it doesn't mean I don't like to, because I do like horror. So yes, that's what we're doing. I'll try and put out a couple of videos for the morning time, and then I was also well, we'll get to that later. So, anyways, let's go ahead and watch this. See, I don't know what most people watch this stuff. I mean, what y'all watch on. So, for example, when we're doing this right now, I'm on my laptop. I mean, obviously, or whatever. So, to me, the screen is fine. But if I leave the screen little like this up here, like, are a lot of you on your phone? Like, do you want me to make this bigger? Is what I'm getting at, or is it like, no, you like it up here? Like, what's the vibe? Where Was God is the name of the Turpin book. Where Was God? It's on Audible. We got a lot of phones, so then this is too small. Y'all need front row for this. Hold on one second. Oh, hold on, wait. Unnamed true crime. Oh, you did? You're right. A little bit. Wait, hold on. Please hold on. Oh, that's so interesting. Untamed True Crime. Will you send me a link to it so I can look at it? Untamed True Crime, reporting live from my sofa at gmail.com. Okay. Oh, so many people run this. See, that's what I usually do too. Okay, so let me do this. Let me make it bigger because a lot of you are on your phone. Okay, where did y'all go? I'm making the screen bigger. This is very challenging for me, right? It's like the click of a button. Like, we just reversed it. Okay, there we go. I mean, this is it. This is a lot going on right now. Good Lord. Okay. Okay, please hold. Okay, where did she go? Now look at this right here. First of all, let's just talk about this. She came in with her hair like she was ready for it today. Wait, hold on. Wait, why don't we hear it? Hold on. Please hold on. Okay, hold on. Let me go change the settings here. I mean, heavens to Betsy. You would think. You would think. Hold on. Okay, hold on. None of that fancy credentialed stuff. Hey, hey, hey. Speakers, USB on. Okay, so now let me try this. Okay. Okay, there we go. Okay, so it's just quiet. You would think. You would think that I would know. Okay, here we go. It's quiet right now, so there's that. She means Schabusiness. He's like, you okay there, Missy? She just looks troubled. She looks like there's a lot of loud noise going on. Oh, right. She does look like Steven, doesn't she? What's his name again? Stephen McDaniel? She's giving Stephen McDaniel. She looks like there's like a lot of like loud noise, which also could be like just like the voices going on in her head or something like that. Yeah, Tina says she looks like she's hearing voices. Yeah, and they're all like screaming and yelling at her and like talking over her. Yeah, she's squint like that, like, you know what I mean? Like, where you're like, okay, like, here we go. Why at this point do they let her lawyers even sit near her? I'd be scared. He's like, hey. Yeah, Joe Guy energy, Jenny says. None of that fancy credentialed stuff. Hey, hey, hey. Emily says medications could be doing that. Very true. Very true. Yeah, I think for her, RGB says she didn't speak to him warning. Yeah, I think literally. You just got a visit from the YouTube channel, The Collector. Oh, I've never heard of that. Is it good? Like, what do they do? True crime? Oh, cool. Thank you, unnamed. He's like doing his pen. I'd have my lazy eye on her now. I'm telling you what now. I want to be comfortable. I want to look away like that. It's going to happen any minute. It's like Jack in the Box. It has me so nervous. Someone's going to say something to her wrong in her head, and she's going to go off. Yeah, gossip says she definitely needs a shock belt. Preach. Amen. If ever there was a situation for the shock belt, I mean, we're in pre-trial and we need the shock belt. Girl can't even go to rec without the shock belt. Okay, she did this where. Yep. Here we go. Here we go, y'all. I think Jack in the Box is not the food, but the toy is accountable for a lot of childhood trauma and anxiety issues. I know in me it is. He's scribbling. Yeah, she's here. Somebody just tapped her on the shoulder, and she's like, "What?"
All right, the court will call 24 CF 1048, State of Wisconsin.
She's annoyed.
Business appearances.
Gordon Leach for the state.
Taylor Schabusiness is personally present. She is in custody with Attorney Curtis Jelka.
All right, this matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right, Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have them.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
Did you say
Off the record.
Hold on, y'all. Hold on. We got to rewind, y'all. Hold on now. We got to dissect this now. We got to dissect this one. Hold on now. Where'd it go? Hold on now. Hold on now. This is some serious shit business.
All right, this matter is set for a preliminary hearing today, Mr.
My officer, I expected her to be here, so.
Oh, you know what? Y'all, we can slow it down. I'm always used to just speeding it up. We can do it both and see how weird it looks, right? Okay.
But I'm also having connectivity problems here.
For sequestration, but that may be a moot point.
All right.
It is one.
All right.
Now look at him. He's just like, yep, just another Tuesday. Hold on, let's do it one more time. Hold on, let's do it one more time. Yeah. This is getting creepy now. getting creepy. This is some devil talk right here now.
Sure.
Yeah, this is creepy. Squinting Cat says, I'm convinced she said WrestleMania. I think she did.
All right.
Yeah, she's looking at the camera. She's upset. No, she knows she's not going to do nothing. Those cops are earning that paycheck today. They're earning it right here. This one came over here. He said, I'll pick the chair up. I feel like I need to be involved too. He said, I'll pick the chair up. She did say that. Listen, I say we vote. Let's just rest on she said WrestleMania. It feels appropriate. I mean, I don't know what else would be appropriate to say in this moment. One might think of things like, I'm innocent. I'm not guilty. But not in this case. Not with Schabusiness. WrestleMania is more on brand. I'm good with WrestleMania. Blank Bunny says Wolverines. Decepticons retreat. What's the other one? Shoulder pads unite. What if she said shoulder pads unite? Shoulder pads. Okay, let's do one more real time. She might have been on that Sarah Boone stuff now. She might be over here talking about shoulder pads unite, Decepticons retreat, Wolverine WrestleMania, Thundercats go. If it was, thank you, Share Bear. If it wasn't that, it was Thundercats go. Okay. Okay, hold on. Let me find it again. Here it is. Okay.
All right. The court will call 24.
Over here, she's like, man, don't be talking to me.
That's
Something like that.
Business appearances.
Gordon Leach for the state.
Taylor Schabusiness is personally present. She is in custody with attorney Curtis Jelka.
All right. This matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs.
Mighty Morphin Power Rangers.
Maybe upstairs. If I can have them.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
WrestleMania it is.
We're off the record.
Yeah. She said Malefotilia. Or no wire hangers. Oh, Danny, thank you for being a member for 5 months. This, yeah, he's very unbothered. Oh, the virus. I can't, y'all. I can't. Oh my, y'all are kidding. This is why I was like, we are going live tonight to watch this. I was like, I cannot with this. Oh my God. Yeah, he was like, it's like, she probably does this every time he gets together with her. You know what I'm saying? Like, this is probably just run of the court, like just normal, right? Okay, now what we're going to do is this. So they subdue her and put her away. So what we're going to do now is we're going to, because I want to hear like what happened. So we're going to watch the legit rest of it with her out of harm's way. WrestleMania.
This is now down in the jail. She's appearing by Zoom in the jail.
Oh, thanks for being a member for 9 months, Shannon.
Yells it up.
Oh, Culinary says WrestleMania is this month. Have any of y'all, hold on, let me pause it. Okay, this is on TikTok. So basically, it's going down the WrestleMania. Oh, thanks, Danny, for keeping the memberships. Okay, have any of y'all seen? I see this on TikTok. Oh my gosh, what is it? Power slap, where the people stand across from each other and they get one. Like I think it's like they get 3 all together, but they take turns slapping each other to see who does a knockout. It's like MMA or fighting or whatever. But it's like I don't even know what you call it, but it's literally just like power slap. She'd probably be good at it. She'd probably knock somebody out. She probably would take a good slap. It's crazy. Slap fight. Yeah, it's literally like where people will stand there, hands behind their back, and you just bam. It's wild. Okay, so let's keep going. Okay, where'd y'all go? Okay.
To the jail. It appeared, I didn't see exactly what happened with it. Here that she tried to get at it. And so the court does now find that Ms. Schabusiness is waived her right to be present during the outburst. Are we prepared to proceed with the preliminary hearing?
Yes, you are.
Your Honor, I'm requesting to withdraw at this point in time.
Your request is denied. For this hearing, State versus case 175 was second one. We can continue for this hearing, and then you can withdraw for that.
Okay, go ahead.
Thank you, Your Honor. The state does call Detective Milan.
Do solemnly swear that the testimony you shall give in this matter before the court is truth, the whole truth, and nothing.
We got testimony.
I do.
She's got some stuff to say. She's seen a thing or two.
Ms. Milan, if you want to state your name and spell your last name. I'm sorry, Detective Milan. If you want to state your name and spell your last name for the record.
Christina Milan. Christina's with a K. Milan is Meilahn.
Mr. Leach.
Detective Milan, where do you work?
I'm a detective at the City of Mount Olive Police Department.
As part of your duties as a detective, do you on occasion review the reports of other officers?
I do.
And as well as do you also review sworn complaints?
Good night, Indy. Thanks for being here.
I do.
And
I hope
those
all's well.
complaints,
Have a good evening.
What do they typically rely on?
Hey, Waffles.
They rely upon the reports
Well, I hope your move went
of the
well.
officers
Yeah, hold on.
that respond to different complaints or incidents within the City of Fond du Lac. They also rely upon witness statements, videos, any other evidence that is brought to the attention of the officers or investigators as they're putting together their case.
Do you know an officer, Lindsay Lukey?
I do.
And have you reviewed reports of Officer Lukey in advance?
I have.
And do you find that Officer Lukey is accurate and truthful in the reports that she makes?
I do.
Now, do you know whether Officer Lukey investigated an incident at the Tuchita Correctional Institution that occurred on July 24th, 2024?
I do.
And how do you know that?
I reviewed the criminal complaint for that matter.
And was that a sworn complaint by your agency?
Yes.
Whose report did that rely upon?
Officer Lukey's.
Thank you. Can you tell us what who's involved in the incident on July 24th, 2020?
Objection, Your Honor. Well, I know hearsay is admissible at preliminary hearings. I don't believe that there are any personal observations from Detective Milan involved, so she's in essence a conduit for hearsay and doesn't have any information of her own to benefit the court.
Your Honor, as Attorney Joe Cook pointed out, the court can rely upon.
Thanks, Kay Evermore.
Detective Milan has testified that that she has reviewed the sworn complaint in this matter that does rely upon Officer Lupke. Detective Mylon further has testified that Officer Lupke is reliable or trustworthy in the reports of the investigations that she reports upon. I believe that would give it sufficient reliability for purposes of the preliminary hearing today.
You answer the question.
Can you repeat the question, please?
Yes, thank you. Do you know who was identified as being involved in the incident that Officer Lupke reported on that occurred on July 24, 2024 at the Cheetah Correctional Institution?
Yes, it was an inmate at Cheetah Correctional Institute, which is located in the city of Fond du Lac.
Thank you, Mbahati. I hope I'm saying your name right.
Taylor Schabusiness.
All right, and are you familiar with Taylor Schabusiness at all?
Not from personal interactions. I have reviewed her photo spread through the Department of Corrections for inmates, which provides her physical appearance.
All right, do you find that reliable?
I do. I use it often.
And can you, did you see Ms. Schabusiness here in court at all today?
I did.
All right, when was that?
Earlier around 8:30 this morning.
All right, and do you see her or her represented in the courtroom today?
I did see her represented in the courtroom today.
All right, and do you see her now?
Yes, she's on the video screen to my right.
And what is she generally wearing? You just described.
Orange jumpsuit.
Your Honor, I'd ask the record to reflect Detective Mylon has identified the defendant in this matter.
Mr. Governor.
Your Honor, no objection, subject to cross.
The record goes forward.
Detective Mylon, what did Officer Lupke report occurred at Cheetah on July 24th of 2024 involving Ms. Schabusiness?
Taylor had.
Thank you, Elaine.
There was a staple in her arm and a request was put in for a nurse to remove it. One of the correctional officers at Cheetah, a female sergeant, was tasked with.
We love Kathy. Thank you.
So the nurse could remove that staple. While in the nurse's office, Taylor began giggling, and then a short time later, when the nurse was in the process of removing the staple with the tweezers, Taylor lunged initially at the nurse. Then the sergeant pushed the nurse out of the way and began to try to gain control of Taylor.
Thank you, Crafting, for being a member. Yeah, a couple of things. You heard her say, Taylor had been giggling. Part of me wonders this. How much of this is an act that she's doing? And when I say act, like I definitely think something is going on. But like the way she was looking at the camera and that she attacked this dude, like this doesn't feel like this feels intentional. I hate using that word. But it's like I just feel like a lot of this is performative. You know what I'm saying? Like, I'm not buying it because I also think that she would be in different circumstances if what they were witnessing behind bars, like when the cameras were off, exhibited this level of unwellness. You see what I'm saying? Like, I don't think she would be in a normal setting. I could be wrong. I don't know. Okay, here we go.
To get the nurse out of the way. And in the
Also, I'm sorry, side note, y'all, when we're done with this, it's only 7 more minutes. I forgot about closed captionings. We are totally going back to the other video and closed captioning it to see what it says when she yells WrestleMania.
process of that, metal tray from the nurse's room was grabbed by Taylor. The correctional officer believes she was struck in the head by that, does not believe she was concussed, but then reported in the course of struggling to get Taylor under control, received bruising to her ribs and pain in her arm.
And did the, was it a sergeant, I believe you said?
A female sergeant, yes.
Thank you. Did the female sergeant, did she report having any pain from being hit in the head?
She reported having pain from the entire incident and did seek medical treatment for potential injuries.
And did the sergeant say whether she had consented to Schabusiness injuring her in that fashion?
She indicated she did not consent to that occurring.
No further questions, Your Honor. Mr. Jalka.
Thank you. Detective, did you review the video in this case?
I did not.
So you're solely basing your testimony on the criminal complaint today, is that correct?
That is correct.
So, just to review, the moment prior to the alleged lunge, there were 3 people in the room? Is that your understanding?
From the criminal complaint, that is my understanding.
And are you familiar with Tachita, whether they have any process for identifying or making sure they have the right patient in the room at any given moment?
I'm not overly familiar with their procedures, but I have responded there for numerous incidents, and most inmates do have a number or a system for identifying them.
You don't know if Ms. Schabusiness was wearing any such identifier that day, correct?
I don't know that.
Okay. So the moment prior to what you described as a lunge, where were the parties positioned, if you know?
I can't say other than the nurse was in the process of taking the staple out at the time, so within close enough proximity to do that.
I mean, even though, so she wasn't there, which I get the point he's bringing up. Not that I'm trying to defend Taylor's actions, because clearly, I mean, you don't need to go too far to get a reenactment for it, right? I mean, you could just be like, well, it's kind of like the way she just attacked you.
Okay. And just to take it a moment further, Ms. Schabusiness allegedly lunged at the nurse?
Lunged or caused some motion in which the sergeant was concerned for the nurse's safety.
Okay. And then did the sergeant effectively intercept her, or did she actually make contact with the nurse, if you know?
I know the nurse was asked if she was hurt. I'm not sure if it was direct contact, incidental contact, but there was questions of whether the nurse was injured.
Now, the person described as the victim in the complaint, that would have been the guard, is that correct?
The female sergeant, yes.
Okay. And she indicated the number of injuries, including pain in her head, but short of a concussion, bruised ribs, and a hurt arm, is that correct?
Correct.
Did she attribute how her ribs had been bruised or her arm had been hurt?
It was not stated in the criminal complaint if she mentioned that.
Okay. But the head injury, I guess, would be related to a tray hitting her?
It was inferred that, yes.
Okay. You don't know anything about the specifics of that tray, correct?
I don't know any specifics other than the nursing trays that are used by nurses.
Okay. Was there any exclamation or sound that Ms. Schabusiness made before she allegedly lunged?
Right before screaming, she did yell, "Thundercats roar, Thundercats roar." And then she said something about WrestleMania, and the rest, I'm not sure. We kind of blacked out.
The only thing that was discussed was like some giggling or some laughing that preceded that. The exact timing of that proceeding was not outlined in the criminal complaint.
But she's always giggling like that.
So you identified Ms. Schabusiness as the defendant earlier today, correct?
Yes,
You have no way of identifying her other than the complaint as the person present in the room at the prison, though, correct? You didn't see any video, you weren't there?
I wasn't there, I didn't see that. The sergeant identified her and the nurse identified her from previous contacts.
Okay. Thank you, that's all I have.
Any redirect?
No, Your
Are you gonna sit down? Mr. Leach, any other witnesses or evidence?
No, Your
Mr. Jelka, any witnesses or evidence?
No,
Mr. Leach?
Your Honor, without argument, the state asked for finding.
the judge would just briefly argue the identification. Detective Island identified Ms. Schabusiness based on booking photos. Doesn't have any personal knowledge of who was present in the room at Rashida, didn't even see the video, so I would move to dismiss, the argument being the identification was inadequate at this time.
The court will find probable cause that the felony was committed and likely committed by Ms. Schabusiness. The case will be found as
Judge Nails.
Mr. Leach, do you have any information?
I do, Your Honor. I'm providing a copy to Attorney Joka and to the court.
Mr. Jelka, subject to local 10-year rule for substitution, do you want to proceed for, with an arraignment?
Your Honor, that was my understanding for today. I would defer to Ms. Schabusiness if she still wishes to continue with that today.
Ms. Schabusiness, do you want to proceed to an arraignment today?
Yeah,
Yes?
yeah.
Okay. Go ahead.
Your Honor, I have received the information. The charges appear to be identical to the criminal complaint. Would waive its formal reading and subject to 10 days to decide whether to substitute would enter not guilty pleas.
Not guilty, please enter this matter. We schedule moving forward. Anything else been stated?
No, Your Honor.
Mr. Jelka, anything else?
No, thank you.
Please adjourn. Thank you.
I mean, honestly, next time she's in court, I mean, do we have to go, set her to the side? Set her to the side. I mean, you know what I'm saying? Like, I mean, what's going on here now? What's going on here? I'll say this. Now, I mean, granted, if I was a nurse, whatever, I'd want to press charges. I want to do whatever. I get it. What a waste of taxpayer money. You know what I'm saying? Take her honey buns away for about 6 months. Reimburse her little prison job to the nurse. Call it good. Okay, y'all, let's go back and see if, what do you call it? They don't have closed captioning. No. That is very unfortunate. We're still going to watch it, though.
Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, so, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have them.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
She totally said WrestleMania. She totally said WrestleMania. I mean, legit, it might be on and she's mad that she's there. She said WrestleMania. I mean, I'm sorry. I don't know what else to say about it. It's just, it is what it is, okay? Okay, now, y'all. You got jump scared. I'm sorry, Wampo. WrestleMania. Okay. Yeah, Vic says she's doing it to be all over social media. Yes, I agree. I think that's part of it too. Okay, so let's go to Daryl Brooks. Let me find him. I don't know if I can handle Daryl Brooks. Now we're gonna speed Daryl up a little bit. just keep in mind, this is the guy who ran through the parade and killed people and then drugged the trial out, represented himself, and just, I mean, jurisdiction. That's right. I was trying to think of the name because I was going to use it on the title because like Schabusiness is Schabusiness. I was like, what is the word that Daryl was always using? It was was it jurisdiction? I mean, if we ever hear that word again, y'all. Also, remember his cringy rap videos? I mean, they were like so cringy. Like I would give props to props for due. You know what I'm saying? They were not. Oh, Grounds. Yeah, Grounds. His rap videos, they're so cringy. Okay, so let me find Daryl. So that's what we're watching. Now Daryl is going to be on the screen over here. So.
Right, and that's a yes, sir?
Yeah.
Can you answer verbally, please?
Yeah.
Thank you so much. And any objection to appearing
I've sped him up to 1.25.
remotely today, sir?
No.
And has the state complied with victim rights? Yes.
There is no
As
CC on
everyone is
this.
aware, the court is
No
live
closed
streaming
captioning.
through the daycast function of Zoom that CCAP has made available for circuit courts in Wisconsin. And we've been able to verify it is up and running. If at any point in time anyone gets word that it is not, please let me know. We are here today to address a motion to withdraw that was filed by
Wait, hold on, y'all. Okay, so where'd you go? Hold on, where are you? Semi says the $100 bill in his teeth. His mom's car. That's so true. That right there, y'all. The way he was trying to, you know what? We're gonna find Daryl Brooks' video after this. Okay, we'll see if we got time. We'll pull Daryl Brooks' video up. I don't even know if it's still out there. I'll look at my phone while we're doing that. Thank you, Lisa. Thank you for laughing along with us. We'll watch this. If you haven't seen it, y'all, here we go.
Attorney Covey. I do want to ask you a number of questions. The first question is it your understanding that Mr. Brooks would still like you to pursue this motion?
Yes, Judge.
All right. And Mr. Brooks, could you also confirm that for me that you are seeking Attorney Covey to be relieved as your attorney of record for your appeal?
Yes.
For purposes of today's hearing, District Attorney Basie, do you agree or is there any dispute that Mr. Brooks is indigent?
I have no information to say otherwise.
All right. And do you have any dispute that we are concerned with Mr. Brooks's direct appeal rights at this point?
No concerns.
All right. Do you agree with those two issues, Attorney Covey?
Yes, Judge.
All right.
He's absolutely indigent.
He's in custody. He's serving consecutive life sentences. He's indigent, and initially, even when he was the accused, was eligible for public defender representation. And do you have any information, Attorney Covey, that would suggest otherwise?
No, Judge.
All right, thank you. Then let me start with some questions. What I intend to do is I want to make a record of a number of things related to the inquiry that this court must make under the law. I think it's important to start with directing the questions to counsel, because as of right now, you do represent Mr. Brooks, and then I intend to address some questions to Mr. Brooks as well. Attorney Covey, have you received and have you reviewed the February 26, 2025 letter from the State Public Defender's Office?
Yes, I have.
Were you aware or have any knowledge of whether that letter was received by Mr. Brooks?
It's my belief that it was sent to Mr. Brooks and that he has received it. I haven't confirmed that with him personally, though.
All right, I intend to do that in short order. Is it true, Attorney Covey, that you were appointed for the purposes of investigating and pursuing potentially an appeal for Mr. Brooks on January 6th of 2023?
Yes, Judge. I was appointed for post-conviction and/or appellate relief.
Thank you. And what have you reviewed in your work on this case thus far?
Judge,
Thank you, Pat.
I have
Thank you,
spent,
Patty Cake.
Probably hundreds of hours. I know this past summer, the vast majority of the summer, my free time was spent reviewing this case, including
Thank you, Semi, and I totally
entire
agree.
record.
It's how
The
it
vast
got me
majority
through
of
my dark
discovery, I'll
times.
make a record of that. There's certainly, when we get provided with lots of audio and video evidence, not all of it is directly relevant to the offense. If, for example, if there's a squad video that's just pointing against the wall, I'm not going to spend hours reviewing that. But the key evidence, the interviews, the court exhibits, I definitely reviewed all of that discovery as well. We have about 5 banker's boxes of materials that I have gone through, including the prior attorney's notes before Mr. Brooks went pro se.
Have you met with Mr. Brooks either in person, by phone, or in any other way?
Judge, I have, and of course I can't talk about the substance of that, but I have met with them in person several times, plus numerous phone conferences as well. I haven't counted, but a large number of contacts.
Have you had written communication with him as well?
Judge, I'll write him letters. Mr. Brooks and I would generally communicate via the telephone, mostly telephone and in person.
Have you sought a number of extensions from the Court of Appeals related to the timing of filing any?
So this apparently is an appeal hearing, and apparently he's going to he's representing himself or something like that. I just looked it up real quick. It says Daryl Brooks Wakasha, I hope I'm saying that right. Parade attacker to represent himself in appeal. He has to represent himself in the appeal process. So it's something like that.
The post-conviction motion or direct appeal?
Judge, I have basically 2 groups of extensions, if I may explain. The file is huge. And so it definitely took me longer than normal to review the contents of this case. And so the first few extensions were just to get me through the summertime where I was able to review all those banker's boxes of materials. The second set of extensions were filed so that Mr. Brooks, after him and I had fully consulted each other, would have time to decide how to proceed. I know one of my more recent extensions was to give Mr. Brooks the opportunity to try to hire a different attorney if his family was able to do so. That's part of the public record, of course. So those are the 2 groups of extensions that I filed over the course of the last year and a half.
Do you know how many?
The most recent extension was the 7th motion to extend time. That was to give, I'm sorry, my apologies.
The record shows that on
I think there was
February 14th, the 8th motion to extend was filed with the Court of Appeals. Would that seem accurate?
Yeah, I misspoke. It's the 8th motion to give Mr. Brooks time to litigate his case. In the event that I withdraw, he'd have a couple of extra months to review the file and to do his own research.
Again, I understand that you can't discuss confidential communications with Mr. Brooks as his attorney, but generally speaking, have you identified issues to pursue on appeal?
Judge, I can say this. There were several very specific issues that I spent an enormous amount of time researching for appeal. As to whether or not there were viable post-conviction or appellate issues, I'm not able to say without breaking privilege.
Have you sent Mr. Brooks any drafts of pleadings related to any appellate or post-conviction issues?
Judge, since I haven't filed an actual appellate brief, we haven't done the notice of intent to appeal, nor an actual post-conviction motion, there wouldn't be any pleadings for me to send him. So we're at the point, if I may, give a little bit more elaboration. Usually it's a 2-step process for post-conviction relief. The first part is actually the longest. It's assembling the court materials. I know the court reporter worked exceptionally hard to get me those materials, but that took a few months. Going through those materials, identifying issues that could provide post-conviction relief. In some instances, there are no grounds for post-conviction relief, and then there's a different set of options that I would go through with the client. So after going through all of those steps, I did have multiple contacts with Mr. Brooks, both in person and over the telephone, for him to decide how he wants to proceed. I'm not able, even if hypothetically I found 5 amazing viable grounds for post-conviction relief or appeal, I wouldn't be able to submit any post-conviction motion or notice of appeal without the consent of Mr. Brooks. If I found no grounds for post-conviction relief, then again, Mr. Brooks would have a set of options that I would have to go over with him. And I can say that we have gone through that process, and he has requested to proceed pro se, which would prohibit me from filing any further pleadings in this matter.
Yeah, at Northwest, I think you said, or claim your fame, whoever did, about the reason he's probably doing this is because there's no real reason for appeal or whatever. I mean, if you saw the trial, you already know. This man was so guilty, y'all. I'm talking like, I mean, y'all, there was just it, like, wow, okay. It is what it is. I pray. I mean, I cannot fathom another trial or in any of this with him running the show. I can't.
I hope that clarifies the issue.
Well, it helps because my responsibilities ultimately, when discussing with Mr. Brooks, is to talk about the options. One option could be a no merit situation. So I genuinely just want to know if all options have been
We're gonna
discussed
do
with
his
him at
music
this point.
video next.
Absolutely, Judge. That I can say
I found
100% certainty.
the one from the trial, but they don't play
And
the
multiple
sound.
times.
But
Is it your
that you don't need the
understanding
sound.
that Mr. Brooks wants to proceed pro se or on his own, or as he sometimes referred to it as in pro person, I think was the phrase he used with some frequency.
Judge, he does want to represent himself moving forward.
Have you discussed with Mr. Brooks your background as an attorney and doing appellate work?
Judge, I don't, it's such it's a innocuous question. There's no issue with me answering it, but I'm afraid that if I were to go into any
Let
discussions.
me ask it this way.
Yeah.
So I would like Mr. Brooks, and let me say it this way. I would like the record to reflect your experience for purposes of my decision here today. So I'll just ask you some general questions. They would not in any way violate any type of attorney-client privilege. First of all, how are you a licensed attorney in the state of Wisconsin?
I hope so. I also am in a lot of trouble today. Yes, ma'am.
How long have you been so licensed?
Approximately 20 years, actually 22 years, I believe.
Do you hold licenses in any other states or have permission to appear in any other courts outside the circuit courts, appellate courts, and Supreme Court in the state of Wisconsin?
Judge, I did take and pass the Illinois State Bar, and I was part of that community for a few years. I let that lapse because I solely practiced in Wisconsin.
What about federal courts?
Judge, I was trained to do some federal courts, and I was actually accepted to be an attorney in the Western District. Then COVID struck, and the caseload for the states became so extreme for lack of public defender appointments that I never ended up practicing in federal courts.
Do you have any area that you focus on in your practice?
Judge, I focus mostly on homicides and sexual assaults, if I may. The state public defender's office, let me backtrack. I'm not a public defender. I'm a full-time criminal defense attorney. For most of the last 20 years, I had my own practice. Recently, I joined Corey Chirafisi for his law firm, CHIRAFISI. For most of the last 10 years or so, I have been practicing mostly homicides, class A, B, and C felonies.
Give me 1 second. Mr.
Sure.
Brooks, would you please direct the camera up? Thank you so much. I appreciate that.
Judge, the State Public Defender's Office has certifications to take certain levels of felonies. The highest level of certification is Class A felony, and I'm certified to do those in both the appellate and the trial court level. Approximately 20% of my work is with appellate work. I'm in trial more often as with the circuit courts.
In your litigation practice, both in the circuit courts and appellate courts, that's both through appointments and individuals who would privately retain you.
Absolutely. I have the highest level of certifications the Public Defender's Office can give.
Thank you. Have you had any general discussions with Mr. Brooks related to appellate rules and procedures, whether it be formatting, initial briefs, what response briefs are, the requirement for reply briefs, or even the difference between that and a post-conviction motion?
Judge, let me just say this again. I've certainly had lots of conversation with I've spent hours with Mr. Brooks in person and over the telephone. I'm going to speak in very, very general terms. The vast majority of those conversations have to do with the substance of the case itself, the issues that I was researching on this case, and there were some very specific issues, which I'm declining to say now for privilege reasons, but that I was researching on this case, going over the case law, meeting with them to discuss lots of different issues. Certainly as part of that, I would have, with every one of my appellate clients, I would have conversations about basic appellate procedures, such as the difference between the post-conviction motion and going straight to the Court of Appeals and why that would occur. that is, as to the details of drafting a brief, rules of citation, the fonts and procedures that you have to do to submit an appellate brief. I, of course, have not had those types of conversations because it was my intent that if there was an appellate issue, I would be drafting that brief. I can say this, and I'm happy to do this to allay the court's concerns. Certainly, it's my intention to send Mr. Brooks a copy of the rules of appellate procedure for Wisconsin. We'll make sure he gets that. Additionally, in my experience of doing this for a long time, though the Court of Appeals will still hold pro se defendants to the letter of the law and the substance of the case. They won't give the pro se defendants any breaks on the substance. If there is an issue with page numbers or citations for a handwritten brief that would be submitted by a prison facility, I've never seen an issue where the Court of Appeals has objected to that. They're a little bit more lenient on those issues for obvious reasons.
Thank you. That was I don't want to say a concern, but a question I had, and that's good to hear. So thank you. Is there anything else you want me to consider in light of the motion that you filed with the court?
Just that I'm not, even if I was allowed to withdraw it today, I'm not going to close the file until Mr. Brooks has the entire file. I was speaking with our paralegal staff just yesterday, going through multiple bankers boxes of materials. The facility where he's being kept at right now will not accept those materials. It's just too much for them to take in. However, if we scan them, download them, and put things on hard drives, multi-gigabyte hard drives, we can send those out. So it will be a very lengthy, time-consuming process for us to do so, but I'll make sure Mr. Brooks gets those materials with one caveat. Because of the time and expense to do that, we wouldn't be making multiple copies. So if something were to occur where Mr. Brooks would want another full set of materials, perhaps 8 months from now, it would be challenging for my firm to comply with that request.
So let me make
We've
sure I
got a
understand.
caveat.
The prison facility at which Mr. Brooks is currently serving his sentences will not accept the volume of material that you have in paper or even standalone electronic other than on an external hard drive.
If we sent them disk and flash drives, I'm very confident that.
Why do they have him in the closet,
they,
in the janitor's
made it
closet?
clear to our office, and it was their staff speaking with my staff, that they would not accept, if I were to ship 5 bankers boxes of materials, they would not accept that. But if we put those materials on computer electronics, then they would have a place where they could store it safely and easily, where Mr. Brooks could access it in their library.
It is not a secret that Mr. Brooks is no longer being held in Wisconsin. If he were in Wisconsin, would you have had better access to him in terms of going to the facility, even with your own computer, and as his attorney showing him discovery if need be?
So I was able to visit Mr. Brooks at the Dodge Correctional Institution, and additionally at the Wisconsin Secure Program facility in Boscoville. The prison facilities made it very easy for me to do the visits. I was able to bring my case files. I wouldn't have brought that volume of materials to a meeting anyways, had I desired to go through any piece of audio video evidence. There would have been a mechanism for me to do so in Wisconsin. If hypothetically, if I were to remain his attorney, I am able to have telephone and Zoom conversations with my clients. It would be a little bit more onerous for me to do in-person visits.
If you were able to do Zoom, you obviously can share screen, even information from your computer.
If that's what we wanted to do.
Do you know what, if any, materials Mr. Brooks was able to take with him from his trial to the facility where he is at?
Mr. Brooks might be able to answer this better than I will, but it's my understanding that somehow along the way, when he was transferred out of state, he no longer has those trial materials. So we would be working to give him a complete set of what we have. And that would also include downloading all the materials from the e-file and putting that on a separate flash drive as well.
But you're willing to do all of that?
Yes, we will get extra funding from the Public Defender's Office to get extra paralegal support to do that.
And they're willing to do that as part of the case closure, should this motion be granted?
I have not put in that request yet, but I am certain that they'd be willing to do it. They've done it before on other cases that were also very serious cases. I'm sure I can get the funding.
All right, thank you.
And frankly, if we didn't get the funding, we would do it anyways.
Oh, I appreciate that. Thank you. All right, Mr. Brooks, I'd like to ask you some questions. First of all, are you aware that Attorney Covey has filed a motion to withdraw as your appellate counsel?
Yes.
And just as a reminder, even though I tried my best to talk to you at my cameras, when I want to watch you for your response, I look slightly down and to the right, or even to one of the other monitors that I can look at. So I just want you to be aware that when I do that, I'm actually paying attention to you. Any questions about that, sir?
No.
All right. Do you want to have Attorney Covey withdraw and act as your own attorney, sir?
At this time, yes.
The Public Defender's Office sent to this court a letter dated February 26th of 2025. It is front and back. I think the actual filing had some additional information on the third page, but that had more to do with who was copied on the letter versus the crux of the letter. But did you receive a copy of that, sir?
From what was the date?
February 26th of 2025.
I don't believe I received that.
Mr. Brooks, would it be helpful if at this point I switch to a single camera when I'm talking directly with you instead of having the multi-camera view?
I can see you just fine.
Okay, great. So I'm just going to read the letter into the record, sir. It's important. It is from Kelsey Loshaw, the Regional Attorney Manager from the Madison Appellate Office. Does that ring a bell at all?
I think from previous letters it might yet.
Well, this one is specific because it was filed after the motion to withdraw was filed, and there's a requirement in Wisconsin Statute 809.30 that the Public Defender's Office advise the court of certain information. Does that help ring a bell, sir?
No.
All right, then bear with me. I will read the letter. It says, "Dear Clerk, in accordance with Wisconsin Statute Rule Section 809.30 sub 4 sub B, I'm writing in response to the motion to withdraw filed by the SPD appointed appellate attorney Michael Covey. The rule requires the SPD to determine whether successor counsel will be appointed and notify the court of the determination. I ask that you pass this on to the judge assigned to the case because the judge is required by Rule 809.30 sub 4 sub C to consider the SPD's response prior to ruling on the motion. The state public defender informs the court and Mr. Brooks if the motion to withdraw Mr. Brooks directed Attorney Covey to file is granted, Mr. Brooks will be waiving his right to public defender representation and no new or successor public defender attorney will be appointed." Sir, have you heard what I just read to you?
Yes.
Are you aware of the risk you take as it relates to to a public defender appointed appellate attorney if this court grants the motion to withdraw?
Yes.
Do you have any questions for me about that?
No.
The letter goes on. An indigent person's right to an appointed attorney for appeal does not encompass a right to an attorney of choice or to successive appointments. State v. Evans, 2004, Wisconsin 84, 273, Wisconsin 2nd 192, paragraph 30. If a defendant decides he no longer wants to be represented by an appointed attorney, he has the choice of terminating counsel's representation and proceeding pro se or with retained counsel. Id at paragraph 31. If a defendant elects to discharge his appointed attorney and proceed pro se, the defendant must be provided clear warnings regarding the dangers of self-representation before appellate counsel may withdraw. Id. Sir, did you hear me read the second paragraph of this letter?
Yes.
Do you understand it?
Yeah.
Do you have any questions for me regarding that?
No.
He's being on his P's and
The letter
Q's
goes
because
on
he
to
wants
provide the
something.
legal framework for the court's responsibility in determining whether a defendant validly waives counsel on appeal. And I'm going to read that paragraph. It is a direct quote from a case, State v. Thornton, 2002, Wisconsin Appellate 294, also found at 259, Wisconsin 2nd 157. for your information, State versus Thornton is a Court of Appeals case that dealt with an issue for the first time in Wisconsin in a decision dealing with the court's responsibilities in determining the waiver by a defendant of counsel on appeal. And in that particular case, and this paragraph starts out by giving a little statement about the state's summary of the issues. The state offers the following synthesis of the foregoing decisions. Before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, 1, of the Flores rights, parenthesis, to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report, parenthesis, 2, of the dangers and disadvantages of proceeding pro se, and 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. The court went on, we agree with the state that ensuring a defendant has received and understands the listed information is both necessary and sufficient to support a determination that the defendant tendered waiver of counsel is knowing and voluntary. In that particular case, the issue or the procedural posture was that the appeal was already pending. And so the Court of Appeals had some further things to say about the communication with the defendant being written. That's not applicable here. I'm having a over Zoom face-to-face discussion with you, but this is the framework that will guide the questions that I ask. Do you understand that, sir?
Yeah, I'm familiar with that case law as well.
Thank you. Any questions for me thus far?
Of course, he's familiar with that case law.
Did you ask Attorney Covey to withdraw?
Yes,
Did he send you a copy of the motion to withdraw?
yes,
Have you reviewed it?
yes,
Do you have any questions about it?
no,
Do you take any issue or claim made by Attorney Covey in dispute?
no,
Did you at any point in time tell Attorney Covey you're fired?
no.
All right.
Judge, if I could just clarify something. The conversations I've had with Mr. Brooks in every instance, they were quite respectful. There was no arguments. So when Mr. Brooks when he asked me to withdraw, it was in a polite, respectful way as opposed to a "you're fired, get out."
Great, thank you. I appreciate that clarification. I still wanted to ask from his perspective. All right. Any dispute with what Attorney Covey just said, Mr. Brooks?
None whatsoever.
All right. Why do you want Attorney Covey to withdraw?
Judge, if I may, Mr. Brooks, this question could cause into some privileged information. You have every right to answer the question. You and I have had lengthy conversations about the substance of particular issues that I have looked at and my conclusions on those issues. I don't think it would be to your advantage to go in that direction. You can definitely answer the judge's questions, but I would just be guarded as to going into the substance of any legal research that I may have done, that I did do. Thank you, Judge.
You're welcome. I appreciate that. I can ask it in a more general way. Mr. Brooks, again, understanding the caveat that your attorney has given you.
We've got a
how would you
caveat.
characterize in general terms the reason you want to proceed pro se? Is it a strategy disagreement, or do you simply just want to represent yourself pro se?
I just want to represent myself.
So let me ask you some real specific questions then about some access to research materials and other things. I believe these questions go to your understanding of the difficulties and disadvantages as a pro se appellate litigant. Most of the time, well, if you file in the Court of Appeals, it is a written process that may or may not include appellate arguments in front of the court. Do you understand that?
Briefly, I understand the outline of what you're saying here.
So you're prepared to follow the rules and procedure of appellate procedure and submit written submissions, whether it be to the trial court or to the appellate court related to your post-conviction and appellate rights?
Yes.
Do
You know it's
have
killing her to have to
what
go through
access
this.
do you have to legal research at the institution at which you are currently serving your sentences?
Honestly, not very much. It's very different. So it would take some time, and maybe a few conversations can be had in that area, but I mean, I don't know if that answers your question.
You've answered it. Thank you. Do you understand that could lead to further delays in your appeal or post-conviction motion?
Mostly.
Yeah, I do understand that.
Welcome.
I kind of anticipate that with where I'm housed. It's like I said, it's a lot different. Things are done totally different here. So I'm aware that that could pose some issues.
You don't dispute that you're no longer in Wisconsin serving your sentences, correct?
I'm sorry, can you repeat that?
You agree, I earlier said you're no longer in Wisconsin serving your sentences. That's true?
I would rather not say.
Judge, I can verify that he's no longer in Wisconsin. The Department of Corrections had requested me personally not to disclose his location. Of course, it's up to the court. I'm sure at some point it's going to get out. But I just had a conversation.
Let me answer that for a second, because
Sure.
we can take a brief segue.
Sure.
I am treating Mr. Brooks no differently than I would treat any individual who's serving a sentence in the state of Wisconsin. I repeatedly asked the Department of Corrections for information where he was at. I'm a separate but equal branch of government, and they thwarted my efforts. I was only told he's in South Dakota and given email addresses for individuals that we could have contact. I need to be able, as the court, to send communication to him directly. That would be no different for any other inmate in the state of Wisconsin, whether they have an attorney or not. So today I directed my clerk to send an email to South Dakota and ask them for the information. It was provided and it is on CCAP. I have received no requests to seal an address. I have received no legal authority from anyone and no request. And so I'm treating Mr. Brooks the same that I would treat any individual, and that information is now on CCAP.
Thank you, Judge.
Mr. Brooks, do you believe that despite
She
some of
got
the
real.
challenges
She
that you described
laid into that right there.
stated about access to research, that you'll be able to overcome that if you are representing yourself?
I mean, like I said, it's going to be difficult, but there are conversations that I'm sure can be had to aid me along the way. But I mean, I have to be honest and say that it will be very difficult.
But do you understand that's the risk you willingly take if you want to be your own attorney and proceed pro se?
It's a risk. It's a risk regardless whether I was in Wisconsin or not. It's just going to be, the question was based on where I'm currently housed, which is more difficult than if I was still housed in Wisconsin.
I understand what you're saying. I'm aware, but do you acknowledge, sir, that that is a risk that you willingly take by asking if I approve the motion to withdraw and you appear as your own, you proceed as your own attorney? You understand that?
Yes.
All right. And again, I'm not trying to be nitpicky here. I'm trying to make a record, and I believe it goes to the dangers and disadvantages of being a pro se appellate litigant who is serving multiple consecutive life sentences, meaning you're in custody, further complicated by the fact that you're serving those out of state, and you don't apparently have the same access to resources as you would in Wisconsin. Do you disagree with anything that I just said?
No.
I want you to be aware, sir, that you have the right to counsel on direct appeal. Do you understand that?
Yes.
Do you have any questions for me about that?
No.
As you know, Attorney Colby was appointed by the State Public Defender's Office, meaning at the government's expense, to investigate and review your appellate options, and that the Public Defender's Office, through that letter that I read to you, has advised they will not appoint successor counsel under really any circumstances. Do you understand that? You want me to restate that?
No, I said yes.
Oh, I'm sorry, I didn't hear you. You covered your mouth, so I couldn't even see your mouth moving. All right, you understand that, sir?
Yes.
Do you have any questions about that for me, sir?
She's not to be messed with.
The right to counsel in this circumstance, and I'm referring to not only 809.30, but the Wisconsin Constitution, Article 1, Section 21, includes the right to a direct appeal, the right to assistance of counsel for the appeal, and includes such thing as the right to opt for a no merit report and abandon an appeal, essentially. Do you understand all of those things?
Yes. Yes.
Thank you. The right to counsel, however, does not include the right to appointed counsel of your choosing. Do you understand that?
Yes.
It also does not include the right to insist that your appellate attorney pursue issues which he in his professional judgment choose not to advance. Do you understand that?
Yes.
In other words, if the only dispute, let's say, is over strategy and you change your mind later on, that's in that circumstance, the SPD will likely not reappoint. I mean, they've said that in their letter. You can change your mind, you can have remorse, regret, you could try to find your own retained attorney, and if that doesn't work out, that once this court grants the motion to withdraw, they will not appoint successor counsel. Do you understand that?
Yes, and to be clear, there was no disputes between me and Attorney Kobe. So there was no strategy disputes. There was nothing of the sort.
Sir, I know from presiding over a previous hearing related to the waiver of attorney that we spent a fair amount of time going through your background. And I just want to confirm a few things with you. You can read, write, and understand the English language.
Yes.
You completed high school through the 11th grade and obtained an HSED. Is that also true?
GED.
A GED. All right, thank you. Are you currently taking any medications that would interfere with your ability to understand what is going on?
Not currently, no.
Right. Do you have any medical issues that would interfere with your ability to understand what's going on today?
No.
Are you under the influence of any alcohol or drugs today?
No.
It is also true that throughout the trial in this case, you represented yourself.
Yes, that's true.
Is there anything about this court hearing thus far that you have not understood?
No.
Are you asking this court to allow Attorney Covey to withdraw as your attorney of record?
Yes.
If you change your mind, I want to confirm once again that you are aware the Public Defender's Office will not appoint successor counsel.
Yes.
Are you aware that if you can't hire or retain an attorney on your own, the Public Defender's Office will not appoint successor counsel?
Yes.
Do you understand, sir, that you will be responsible for all aspects of your post-conviction litigation and appeal, including compliance with all court rules and procedures?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney in this case?
No.
Anyone make any promises to you in exchange for your waiver of right to an attorney?
No.
Do you believe you're making the decision to waive your right to an attorney freely, voluntarily, and intelligently?
Yes.
Do you need any more time to talk to Attorney Covey regarding your request that he withdraw?
No.
Do you further understand you may need to file motions in the Court of Appeals seeking an extension of time? Given the most recent extension goes to June 3 of 2025.
Yes, I'm aware. I didn't know it was that soon, but yes, I do understand that.
Judge, may I jump in for 1 second?
You may.
Thank you. And just for the record, we have sent Mr. Brooks copies of all of our extension motions and the Court of Appeals decisions. What I will do for Mr. Brooks is I'll send him again that my most recent extension motion that he can use as a template, and I'll include a closing letter with the instructions as to how to file that and to use a pre-appeal case number, some of the basic procedural issues that might help him understand the difference between a post-conviction motion and going straight to the Court of Appeals. Is from my experience, the Court of Appeals is pretty lenient in giving at least several extension motions to pro se defendants. At some point, they'll put some harsher deadlines on. It's a gray area, but I am very, very confident that he'll have more time than June 3rd if he makes a proper request to have more time. It might take a couple of weeks for us just to get at those files to him. We've been working on it.
Mr. Brooks, do you understand that if the court permits Attorney Covey to withdraw today, you would be responsible to file the next extension request?
Yes.
And you are prepared to do that?
Well, once I receive the templates that Attorney Covey is going to send me, yes, I'll be ready to do that.
You understand he's not required to do that. He's just offering to
Yeah,
do that, and it would not.
I know.
All right. You understand that's still something you are responsible for, whether he sends you that template or not.
Yes.
Is there anything else you want me to know or consider today, Mr. Brooks, as I consider the motion to withdraw?
Not really. I think everything was pretty much covered. Just a understanding should be there that, again, this facility is a lot different. So there are different types of hurdles that I've already seen that I would have to jump over to be able to get things done. So I just want that to be stated for the record. That it's just a lot different, and there's a lot of different procedure wise things here. So I'm still navigating that, as I haven't been here that long. So I'm still learning as I go. So that's it.
And you're willing to take on your own case with that difficulty and those challenges related to the institution?
At this time, yes.
Attorney Colby, anything you think I've overlooked here today as it relates to this motion?
Judge, I'm very satisfied with the colloquy. I think just to make a record, I have just one other issue. If I may ask Mr. Brooks a quick question.
Go ahead.
Mr. Brooks, I know you talked about that there are some difficulties. I just want to make sure, are you still allowed to have access to your legal files?
So the legal files is something that I haven't been explained. I didn't know that there was conversations about the whole flash file thing. I haven't even heard anything about that. I really don't know how. Somebody maybe here can explain to me how that will work. So I'm kind of like trying to figure it out myself, actually.
Attorney Covey, it's my understanding, based on what you said, I mean, you believe the institution will accept the external hard drives, obviously any paper that you send through regular mail, just not finger boxes or large boxes full of materials.
Yes. So if I were to send them a 40-page packet of materials with appellate rules of procedure and extension notes and templates, I think any facility would allow that to be processed through, so long as I don't have clips or staples. As for, but they balked. My initial email, I don't have this memorized. I don't want to make a false statement, but my initial recollection when I first contacted that prison facility was to say that we were going to send them the files. I was told they would accept the file, but then when I stated, or when staff stated that it would be 5 bankers boxes, they put the brakes on that. And then there was some correspondence between their legal staff and my legal staff as to the best way to do this. We'll likely be buying some terabyte hard drives to put the materials on that to send to him. I don't know how much access you'll have to the library. I know in Wisconsin, you can go in almost every prison facility, unless you're in some kind of segregated status for a fight, for example, with another inmate, that you can make reservations to go to a computer library to review your legal documents. I also know that the time is quite heavily rationed. He's not going to have 8 hours at a time to look at these documents. So that will be a challenge for him.
I was just going to say that too.
It's giving
there's
Sarah
no law
bone.
library, which I've never seen a jail or a prison without a law library. So
The audacity of
I don't
them.
know how that's going to work.
Do you have access to anything through a computer or online to access research material?
I have access to look at I believe it's Westlaw, and those are tablet based. But even that is challenging.
I use a tablet-based Lexis. It's a similar platform. It can be cumbersome unless you know how to switch to the natural language search engine and how to limit the jurisdictions and what you're looking at. But I think it's similar to what you had when you were in Waukesha, is that not?
No, Waukesha had Lexis, or however you say it, Lexis, Nexus, or
Oh, they're very similar. If you figured out Lexis, you can figure out Westlaw, in my humble opinion.
Judge, if I may add one thing.
Go ahead.
Mr. Brooks, I know that without going into the substance, I recall about a 2-hour meeting when we went over a large amount of case law together. What I'm happy to do is I can send you those copies of those cases that we discussed.
I appreciate that. Thank you.
Thank you.
Thank you. District Attorney Basie, is there anything the state wants me to consider or any additional information from the state today?
You got it.
All right, then, as I indicated earlier, and I'll just go through some of the law that pertains to this issue in making my decision. A person convicted in Wisconsin of committing a crime has a constitutionally guaranteed right to appeal his or her conviction to the appellate courts. That's directly from the Wisconsin Constitution, Article 1, Section 21, and case law State versus Perry, 136, Wisconsin 2nd, 92, a 1987 case. The right to an appeal includes the right that the appeal be a meaningful one. An indigent defendant is constitutionally entitled to the appointment of counsel at public expense for the purpose of prosecuting his or her one and only appeal as of right from a criminal conviction. And I'm citing to or from State versus Thornton, and that again is 2002 Wisconsin Appellate 294. And that court was citing to the U.S. Supreme Court in Douglas versus California, 372 U.S. 353 from 1963. There's no dispute here today that Mr.
Beverage
Brooks is
refresh. Be right
innocent.
back.
This
We only got like
court,
8 minutes left of this one.
noted previously, I've dealt with this issue with Mr. Brooks previously prior to trial, but a criminal defendant may waive his or her right to counsel in criminal trial court proceedings, provided the record reflects that the waiver is knowingly, intelligently, and voluntarily made, and that the defendant is competent to proceed pro se. That's a citation to State versus Klessig. Appellate or post-conviction counsel appointed by the state public defender may move to withdraw from representation of a client, and in determining the motion, the court shall consider whether the defendant waived the right to counsel, and that's Wisconsin Statute Rule 809.30 sub 4 sub C. As I indicated earlier, at the writing of Thornton, no Wisconsin appellate opinions address the requirements for effecting a valid waiver of appellate counsel. Thornton relied heavily on Omen versus McCoutry, which was, although a Wisconsin case at that point in time, it was before the 7th Circuit Court of Appeals. The citation for that is 130 F 3rd 809 from 1997. I did review that case as well. And from that case, the Thornton court stated and found that before a court may conclude that a criminal defendant has knowingly and voluntarily waived his or her right to counsel on direct appeal, it must satisfy itself that the defendant is aware, one, of the florist rights, which I talked about, that's the right to an appeal, to the assistance of counsel for the appeal, and to opt for a no merit report that was briefly mentioned previously. 2, the dangers and disadvantages of proceeding pro se, which this court has, I think, exhaustively gone through with Mr. Brooks. And 3, of the possibility that if appointed counsel is permitted to withdraw, successor counsel may not be appointed to represent the defendant in the appeal. We know from the letter from the State Public Defender's Office, they will not appoint successor counsel, and that's a citation to document 690, filed February 26th of 2025. This court is satisfied that Mr. Brooks is freely, voluntarily, and intelligently waiving his right to appellate counsel. He confirmed many of the same requirements, if you will, that I went through with him at the time of his waiver back on September 28th of 2022. I just want to, I'm not going to read the entire excerpt into the record, but I am looking at the transcript, which is document 580 from that hearing, pages 75 through like 77. The court makes some findings that I believe are confirmed here today, and that's, he said today he had a GED that may have been referenced as an HSE.
Okay, sorry.
They're very similar. Nonetheless, Mr. Brooks has a high school equivalency diploma.
Had to get my popcorn.
Or a general education diploma. He's been able to communicate very clearly with not only counsel, but with the court. He's done that efficiently and effectively. He did not have questions for the court today. Frankly, this procedure went much more smoothly than the procedure and the questioning and answers back in September of 2022. And so I'm just going to rely and incorporate herein by reference many of the findings or all of the findings I made back then, because nothing has been presented to this court that would dissuade it otherwise. That he's
Amy.
intelligent, he understands the dangers and
Yeah, they came running with the popcorn.
Proceeding on his own. He's made the request. He now knows the SPD's position. He indicated it doesn't change his mind. We've discussed many of the potential pitfalls of proceeding on his own. He's in an out-of-state facility. He does not have the same access as he does in Wisconsin. We have some wonderful offers by Attorney Covey to send him additional information. He's aware he needs to file for an extension because the current deadline in the Court of Appeals is June 3 of 2025. He So I have met, and through the colloquy here today, the requirements of the Thornton case, and I'm satisfied that he's doing so again freely, voluntarily, and intelligently, and with an understanding of really the dangers and disadvantages, and of his rights to an appeal and to appellate counsel. And for all of those reasons, the court will grant Attorney Covey's motion to withdraw. And from here on forward, the court will consider Mr. Brooks a pro se litigant. We will be able to communicate directly with him. I would like an order. I don't recall if you sent a proposed order in, but if you would do that, Attorney Covey, I will certainly review that, sign it, and then we will send that on to Mr. Brooks.
I'll get that done before the end of the day.
Thank you. Mr. Brooks, anything else from you today? Attorney Covey?
Judge, I will make a request. Generally, once I'm allowed to withdraw, I'm cut off from the e-filing. I would request that I have the opportunity to send Mr. Brooks all of these materials. Then I can file a letter with the court saying that we have done so, make a record of that. And then at that point, perhaps I can be cut off from the e-file if the court so desires. If there is some kind of issue where the prison won't accept anything, for example, then we would be able to address that. I just want to make sure that he gets his materials before I truly end my representation on this case.
You're asking that I delay the approval until you've been able to pull everything off from the court file that you currently have access through as an e-filer.
I guess so. You can sign the order at any time. I don't, and oftentimes I'm kept on the e-filing system even after I've been withdrawn. It's just kind of a quirk of the e-filing system. So we can sign the order at any single time, but I would, as a friend or as a courtesy to the court, I could still draft an update letter letting the court know that these materials got sent out. I'm not trying to complicate it.
That's okay. My clerk is advising me that we can delay removing you even though I signed the order of discharge.
Thank you, Judge.
Any objection from the state?
No, Your Honor.
All right. Anything else from the state today?
No, Your Honor.
All right. Thank you, everyone. That does conclude the hearing today. For purposes of our live stream, we just not turn it off for about 30 seconds or a minute because there's a delay in the broadcast, and we want to make sure everyone gets there.
Thank you.
To the end. Thank you, everyone.
I mean, I'm like, how did we end up back here again? I can't believe she granted it to him. Right? I'm just like, hold on, let me put these up here. This is becoming all we've been very fighty today. We don't need to get any more reasons to fight. That's it. Yep, they're all gone. Nobody got anything. Oh, sorry, sweetie. Okay, so what we're gonna do now is we're gonna watch the thing from his rap video. Oh, wait, give me. Hold on, they're trying to figure themselves out. The dogs. Okay. From his rap video. Okay, let me just please hold. Everyone just please continue to hold here, okay? Your call is important to us. I cannot roll my eyes hard enough. Hold on.
We're going to.
Okay, where'd y'all go? Okay, so we're getting ready to watch Daryl and Court of how do you say it? The first trial he went through. Now they don't play the sound to the rap video, and I'm not gonna play I'm not gonna find a way to do it because I don't want it in some way to get music gets weird on YouTube. But you don't need to listen to any of it. You can just watch it. But we will be hearing him talk about them playing it and whatnot. So it's it is what it is. You'll see. You'll see. I promise. Math Boy Fly.
Play it in its entirety, but without volume, Your Honor.
All right, thank you.
Oh, he doesn't like
And,
that.
I object to that, and I would like to make an offer of proof of my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without
Your
audio.
Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that's not, that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
Actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
He got under this lawyer's skin, y'all. He had
So we'll play
her
the entire
ruffled.
video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about,
about
I
his
question him
knowledge.
about the still frame from the video. The video wasn't even in the exhibits that I received.
He's got $100 bill. That's his mom's car.
I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying.
The
He's gonna
car
explain.
behind him is the one that he used to kill the people. Right? Correct me if I'm wrong. The jury already knew he was an idiot, right? They didn't need to. He's thinking this is going to make him look a certain way. It's like, dude, they already know.
So play the sound. I want to hear it now.
He's trying to get some
We'll
promotion.
address that later.
We address why it was created out of the Bluetooth.
There's another one where he's in the kitchen. Y'all know what I'm talking. Wasn't it Daryl? Was that another dude? Wait, who was the one other dude that killed? God, what was that? There's another guy. Or was it Daryl? No. It was him in the kitchen. It was in the kitchen. You know, the jury, by the time this was over with, not just the video, but the whole case was like,
Go ahead, attorney, after the video is finished playing.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled foundational, the witness may answer.
Yes, I
A lot of
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now.
see, people aren't used to what I mean. People like see the people, the professionals and whatnot. They're not used to somebody just sitting there just spouting off like Daryl did, right? I mean, like it's just, and I mean, he's just saying anything, no filter, whatever just pops out of his mouth. It's just what he's gonna say, and it's just it's insanity. Okay, now one more thing. Let me just find or see if I can find this one more thing. Please help. Please continue to help. Okay, please help. Hold on one second. I'm just looking around at this now. The other one's not as popular. Hold on. I mean, it's just this trial was so viral. I'm not seeing the other thing. We'll just leave it at that. Gosh. Okay, let me find y'all. Where'd y'all go? Here you are. Okay, there. So y'all, so we'll see what I can't imagine that he's going to get the appeal, right? So correct me if I'm wrong. It sounds like what he got is he can represent himself trying to get the appeal and go through these things. And then obviously if he wins, the chance for an appeal, there you go. But he's being very well behaved. Because here's the thing: when Daryl wants something, he acts like what we just saw, not in the rap video, but in the in his hearing, right? When he's trying to get something, he reels it in, which shows you that he 100% knows what he's doing. 100% knows what he's doing. Oh yeah, that mouth of his 100% got him the beat down. Absolutely 100% earned him a beat down. You got to remember this too, though. I mean, didn't he? Correct me if I'm wrong, y'all. I know he killed an elderly lady. Did he kill a child? Because I feel like he either killed a child or he really hurt a child. So what I'm getting at is, and I can't remember off the top of my head, his crimes are not like okay crimes to have in prison, right? And then you accompany it with his mouth and the way he likes to run it. Oh, please. I'm honestly surprised he's alive. I'm honestly, okay, 7 years. That's right. Yes. I'm shocked the man is alive. I mean, it's just how he has managed. So yeah, and this is my understanding. Correct me if I'm wrong. I keep saying a lot, but you know what I mean? Isn't he at Chris Watts? Didn't they move him to where Chris Watts is or something like that? Hey, what's going on? You chewing your little cage up over there? Hey. You want to say hey? Say, I have been a very bad boy today. He is going toe to toe with Oliver. He has been squabbling with Oliver since last night. Okay. Where's your brother? What's your brother doing? He's chewing his little thing up. Is he chewing that up? Yes. Oh, you want your little thing? Look, there you go. Look, Bubba. Come on. Lay down. He's like, no. Dodge Correctional Facility. Okay, thanks, Barb. Yeah. So, I mean, here's my thing, right? I can't believe that he's still alive. So he just wants something. That's all he wants. We'll see what he gets. As far as Taylor goes, I mean, she can't even get through a thing without attacking somebody. Yeah, but again, and this goes for both of them, really, and anyone in this situation. They're never walking out of prison. There might be a slim, tiny chance, right? But for the most part, they are not walking out of prison. They're bored. It's something to do. You know what I'm saying? It's drama. It's attention. It's something to do. I think we'll always hear about Taylor in the headlines. I just think that she's a troubled person. I think Daryl is too. I think it comes out in different ways. Daryl will always be kind of in and out of court. He likes cosplaying a lawyer. Shannon says something to stay relevant. Yeah. I mean, it's just, again, at this point, they're bored. Like, you would just be like, sure, I'll go to trial. You know, oh, you got an open container charge against me in whatever state. Well, let's take it to trial. Why not? You know, it's like, you know, I mean, and on that theory, they could almost do stuff in prison to like Schabusiness. Maybe she wanted to do something. Maybe she caught a charge on purpose. Yeah. Amy says they need to be on lockdown in a psychiatric hospital. I do feel like Taylor Schabusiness would be, if that was still more of an integrated part in the prison complex, whatever you call it, I think she would be probably in there in some level. And maybe she isn't, I don't know. Maybe she's in some form of a mental health geared facility, but I'm talking about like what it used to be. Because I just, I don't know. Yeah, Lori. So speaking of that, so just a reminder for people who have just joined, Monday, probably at 10:30, we'll start streaming because there's gonna be a 30-minute lag. We'll start streaming 10:30 a.m. Eastern. Pardon me. Wait, is it gonna be that right? It's 10:30 Eastern time, right? That we'll start streaming. I need to look at that. Is it going to be 10:30 a.m. Eastern time, or are they going by Arizona time? Like when they said, pardon me, like when they were doing the thing, is it different time zones? Please out. 10:30 Arizona time. So wait a second. So please stop. Wait a minute. So you're telling me that trial doesn't start streaming here till like 1:30 in the afternoon? Are you serious? That is crazy. I mean, it is what it is, right? I don't know but here's the thing, I can get a lot of stuff done during the daytime. So it's gonna be some late nights for us. I mean, this is gonna be interesting. Brent says finally a trial closer to my time zone. Okay, so it'll be if you're watching Eastern time, if you're in my time zone, and then if not, just do the math on it, whatever. So we will start streaming in the afternoon around 1:30, and that's what we'll do, and that's what we'll do. And yeah, so anyways, so Lori Daybell trial 1:30 Eastern time on this channel. We will stream it. That's how we'll do that. This Sunday evening we'll watch Zulema. What's today? Friday. We'll recount, or we'll rewatch her thing or whatever. And that's what we'll do. And Brenda says, are you streaming tomorrow night? I'm not planning on it unless something pops off though, right? So if something like pops up, meaning like this right here. Like I wasn't planning on going live tonight, but like this, I was like, oh please, right? We have to watch Daryl Brooks and Taylor Schabusiness in the same day. Come on. Well, Taylor Schabusiness popping off. Yeah, right. It is what it is. So what we'll do, oh, thanks, Bewitched. I appreciate it. So yeah, so if something pops off tomorrow, whatever, we'll do that. But by default, Sunday evening we'll well, hello. We will do Zulema. And And then that's kind of that. The Monday, afternoon, we'll start with Lori. Bringing justice for Charles Vallow. Hey. Oh. This one. Oh, Luke doesn't want to be touched. That's Luke, who was just up here. You want to come say hey? Or you're a little feisty, aren't you? I can see. He's a little touch me not. So, but that's it, y'all. Thank you for hanging out with me last minute, y'all. This is so much fun to watch this together. This is a blast. Thank you, mods, all the mods for jumping in last minute like that. I emailed them like an hour, not even that, like probably like 30 minutes before. I was like, hey, y'all, I'm gonna like total last minute. We're going live here. So thank y'all so much. I appreciate it. This is a much needed laugh session. To bring in the weekend, I guess you could say, and I hope everybody has a good weekend. So that's up. I will talk to y'all at WrestleMania. That was so funny. Oh my goodness, y'all! I needed that WrestleMania. Oh, I just love it. I just love it. So that's it. I love y'all. We will cue our little Sofa Squad song now. Y'all have a good Saturday morning, and I will see you at minimum Sunday evening on this channel, Sunday morning on the other channel. Good night. I love y'all. See you later.
The pillows are fluff thanks to Miss Emily. The couch is wide enough, join the family. It's all love while we laugh at first criminalities. Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Oh, please, the puppies need me. Ooh, oh, please. My body is rejecting none of that fancy credential stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup and hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough. Puppies need me, oh please. My body is rejecting none of that fancy credentialed stuff. I'm just here for the cringe binge. Hey, 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 welcome to the Sofa Squad. Sipping from the cup that hey, hey, hey. Come laugh with the Sofa Squad. Can't roll my damn eyes hard enough.